Hello, everybody. Thanks for coming. I hope you had a great winter holiday. My name is Travis Pantine. I'm the director of the Insurance Law Center at the University of Connecticut School of Law, and I'm very happy to kick off with my colleague, Professor Peter Siegelman, this next semester of the New Ideas in Insurance Law online workshop. For those of you who are joining us for the first time, welcome. As background, what we aim to do here is draw in a diversity of thinkers and scholars and practitioners from various disciplines to talk about insurance law broadly construed. So what we hope to do is create a venue here for conversations about insurance that's interesting, not just to legal academics, but also to practitioners and regulators and students and public servants and everyone under the sun. So our attendees are similarly mixed. We have law professors, students, many of our own LLMs in insurance law join, and in some of our JDs. We have regulators, lawyers, and if you don't fit into one of those buckets, you're still very welcome. And we encourage you to bring your friends. And on that point, as you know, this workshop is open to the public, and it is recorded and posted on our website. So just keep that in mind. Before I hand over the mic to Peter, a few more short notes. So in terms of format, the presentations generally last for about 30 to 45 minutes, leaving 30 to 15 minutes for questions. Peter or I will keep a queue. So if you are interested in asking a question, please use the little hand raise function on WebEx, or you could write it in the chat. The readings for these sessions this semester are posted ahead of time on our website, and we encourage you to read them ahead of time, although we won't hold everyone to that if you're unable to. And this workshop will be held at the same time on alternating Thursdays at 4 p.m. Eastern in the fall semester. So if you're already working on your fall semester schedule, we encourage you to block out the time slot now. And one last announcement. So we are hosting a conference here at the Insurance Law Center at the UConn Law Hartford campus in May on this topic, on ESG and insurance, which is a pretty broad topic. But if you are interested in the topic and you want to come join us, I'm going to paste a link in the chat to the registration form, and we'll send you some more information. The workshop or the conference will be free and open to the public and hopefully very interesting. So I encourage you all to come up to Hartford and see us in person then. So with that, I'll hand it over to Peter.
Great, thanks. So I'll be very brief. It's great to kick off the series with a paper and presentation about the most important issue facing the world today, without doubt. And we have as befits the international nature, the global nature of the problem, we have a global cast of presenters today. First, Susan During, who's the head of climate risk management solutions at WTW, also known as Willis Towers Watson, which is an international consulting service, risk management, and insurance brokerage. She has a long background in environmental underwriting and environmental risk management. Michelle Radcliffe is also with us from London. She's the director of WTW's Climate Analytics and Exposure Management Group. And finally, Martin Lockman is here on this paper and here as well. He is the climate law fellow at Columbia University's Sabin Center. He has a background in renewable energy finance at a top 100 law firm, but also has a background, interestingly, as a community activist in the coal fields of West Virginia. So that's quite an impressive collection of people talking about an important and interesting topic, and I look forward to hearing what they have to say. Thanks. Please join me in welcoming them.
Martin, I'll just jump right in. All good?
Yeah, thank you very much.
Excellent. Thank you, Travis, and thank you, Professor Siegelman, for hosting us. And thanks to all of you for joining us today. As Professor Siegelman indicated, I'm Susan Deering. I'm head of Climate Risk Management Solutions for North America at WTW. This afternoon, Michelle and Martin and I will be sharing results of our research on climate litigation, and the details of this can be found in the research paper and white paper that were released in 2023 entitled Climate Litigation: Is There Shelter from the Storm, as you see before you. We're very enthusiastic about our topic, so we're going to work really hard to keep our comments succinct and leave time for questions at the end. Yeah, again, we're going to try hard to do that. Some of you may know that WTW has a rich history of research, analytics, innovation, and insurance program structure and placement around climate. For a couple of decades, actually, our Climate and Resilience Hub has been an innovation incubator. They gather data. Their research is fueled by data developed through the Willis Research Network's engagement with universities and government research institutions around the world. As insurance and brokers, we've all been acutely aware of the impacts of climate change and climate change driven extreme weather on our property books, our clients' facilities, and on their bottom lines. But what has been less well tracked and less well understood up until this point is the evolving area of climate litigation, which is what we're going to talk with you about today, and what impacts that's going to have on insurance portfolios. So to that end, WTW partnered with the Sabin Center to delve into the area of climate liability, both to help insurers to understand how they are at risk and how to manage their portfolios, and also to help our policyholders to understand the risks and position them all well to predict those impacts and deploy protections. As brokers, we're also eager to stay ahead of this emerging area, and we work with our insurer partners on opportunities for coverage innovation to better serve and protect clients. Our presentation today is the result of the unusual collaboration amongst WTW's Insurance Consulting and Technology Group, represented by my colleague Michelle Radcliffe, and our Corporate Risk and Broking Group, which is where I live at WTW, and our partners from the Sabin Center, which is where Martin resides. So let me ask Michelle and Martin quickly to introduce themselves, and then Michelle is going to get our presentation underway.
And I'll let you go first, and then I'll sort of start in the presentation.
Thank you. Yes, as Peter already mentioned, my name is Martin Lockman. I'm a climate law fellow at the Sabin Center for Climate Change Law and associate research scholar at Columbia Law School. The Sabin Center for Climate Change Law is celebrating its 15th anniversary this year. It was founded on the day that President Obama was inaugurated for the first time, so we've seen a lot of change. We currently have around 20 research attorneys working on a variety of climate change related legal issues, ranging from traditional environmental law to kind of complex international law around geoengineering to my area, which is climate related financial risk. And Michelle, I'll give it to you.
Awesome. Good afternoon, everyone, and yes, thank you for inviting us to speak with you today on this topic. So I'm Michelle Radcliffe. I'm a Director of Climate and Sustainability at WTW, as Susan said, in the Insurance Consulting and Technology team. Now, my background's actually in law, so I trained and then spent 15 years as a qualified lawyer in the international law firm CMS. Now, the majority of my career was spent as an insurance lawyer, so providing policy coverage advice to insurers across a number of lines of business, acting in defense of claims and arbitration, adjudication, high court proceedings, drafting policy wordings, and assisting in the development of new products as well. So most interesting, probably cyber insurance, which was about 11 years ago, and then acting on some very large cyber class actions. I've also spent time on secondment in insurers in claims, legal, and underwriting as well. Now, as part of my role on a panel for a number of different insurers, a lawyer, I was often asked to advise on future areas of risks. Now, climate had always been on the risk radar. Back in 2015, 2016, though, it was one of a number of emerging risk areas. Now, in 2017, I'd been doing a lot of work for Grant Thornton, and I attended a small roundtable dinner where the keynote speaker that night was a lawyer from Client Earth, which I'm sure you will all have heard of. And he had just written a paper discussing the risk of claims against auditors for not reporting on climate risk. Now, for me, as a claims litigator, the idea in 2017 that auditors could be held liable for not reporting on climate risk seemed a very long way away. And yet we fast forward to where we are now. The FRC, who regulates auditors in the UK, now has a focus on auditors' responsibilities from a climate-related risk, which really shows how far we've come in such a relatively short space of time. But that Client Earth paper back in 2017, which interestingly is the same year that United Nations started to track climate litigation cases, really sparked my interest in this area and ultimately changed the course of my career. I deep dived into climate litigation and really have spent the last 7 years tracking all climate related developments globally. So understanding how these developments may increase liability risk for entities and hence insurers and reinsurers, but also the changing reporting requirements, the transition risks, the physical impacts of climate. And it led me to move departments to practice as an environmental lawyer, which included a very interesting comment at Amazon in their environmental legal function. And then I moved to WTW this time last year to advise insurers on reinsurers on climate and sustainability risk. So both at a corporate insurer-reinsurer level and an underwriting level as well. So the focus today is obviously on climate litigation and insurance. And if we go on to the next slide, and I promise you I'm not going to give you a science lesson, but just to briefly sort of mention what is prompting a lot of this type of litigation. Now, as you know, we're in a climate challenge. Martin, if you just click on the next couple, there we go. Thank you. Global average temperatures are increasing and the profound change is needed to slow that temperature increase. The consequences of not doing so, as we all know, are very severe, not least given what are referred to as climate tipping points. So those thresholds, which ultimately once crossed, lead to large, accelerating and often irreversible changes in the climate. Now, I'm sure you're all familiar with the Paris Agreement, where the goal is to hold the increase in the global average of temperature to well below 2 degrees above pre-industrial levels and pursue efforts to limit the temperature increase to 1.5 degrees above pre-industrial levels. Now, with the Paris Agreement, in a very short format, there's essentially a huge raft of legislation and regulation aimed at countries to help in achieving those goals, which is particularly so in Europe. So we have what's called the European Green Deal. It's a set of policy initiatives by the European Commission with the overarching aim of making the European Union climate neutral in 2050. But for many, these new legislations, new regulations, government action is not seen as enough. And that's where historically climate litigation has started to fit in. Now, I don't have time today to sort of do a sort of changing nature of climate litigation over the years and the different actors in that litigation. But suffice to say, if we go on to the next slide and just look at the number of climate laws and policies and the number of cases, if I had shown you this slide back in 2017, when I first started presenting to insurers on climate litigation, this would have looked very different. Certainly fewer climate laws and policies and certainly fewer cases in a lot less jurisdictions. Very few would have been in the global south. Now, historically, we've referred to climate litigation as agenda setting litigation. So often the type of litigation where often very little is sought by way of monetary damages. It's about changing corporate behavior ultimately. But we've really seen a shift there, not least given the interest in litigation funders, the growth in group and class litigation, which we've seen in this area. And while we can see from the map that the US still dominates in terms of the number of cases, the growth in other jurisdictions, particularly Australia, the UK, and parts of Europe, as you'll see from the bar chart, is significant. Now, it's worth noting that not all cases referenced on this slide are against private sector companies, which is obviously where insurers face most risk. But this is an increasing area of concern for insurers, reinsurers, and of course regulators as well, who want to and ultimately need to ensure that the insurance market has embedded climate financial risk within their organizations. It's becoming increasingly a regulatory requirement, whether you're in Bermuda, in London, in Singapore. And I'll speak later on what a number of entities are doing and how we're working with them to help embed climate financial risk from a climate litigation perspective as well. But I'll stop there. I hope that's just a kind of a useful introduction to set the scene. And I'll pass you over to Martin now, who will talk through the different types of climate litigation, because I think it's really important to remember that these types of cases vary significantly. It's not just the fossil fuel cases that you read about often in the press. There's obviously a lot in the US, which I'm sure Martin will reference, but they can arise out of what I refer to as transitional legislation. So that legislation which is really growing and is aiming to assist countries in reaching their goals as set out in the Paris Agreement. So I'll pass over to Martin now, and I'll speak later on about what we're doing in practice with insurers and reinsurers in this area.
Thank you very much, Michelle. So I'm going to give an overview of what private climate litigation looks like. And this is a novel and quickly changing area of law. As Michelle mentioned, the vast majority of climate litigation cases historically have targeted governments and government actors, but we're seeing increasing numbers of claims against private companies. And while some of these claims, like the massive lawsuits against oil and gas companies, are probably familiar to you from the news, climate litigation encompasses a really diverse set of claims that impact a wide variety of industries and industrial actors. Different categories of claims are really substantively very different. And even though a lot of these cases are bringing new legal theories, we can start to organize them into three main different areas. This is important because these three main different areas are driven by different factors, impact different kinds of defendants, and have really different implications for insurance coverage. I will also say that these different categories are not a strict legal categorization, and claims may overlap. They may fall in one category or the other, but these categories are designed to help you think about, specific claims and how they relate to others. So first off are the mitigation claims. Mitigation claims are disputes that arise from a defendant's alleged contribution to climate change or a plaintiff's attempt to limit future greenhouse gas emissions by a defendant. These are the big claims that you probably think about when you think about climate change litigation. Lawsuits against oil and gas companies, power companies seeking damages for climate-related harms. They also include some suits against organizations that support or otherwise contribute to greenhouse gas emitting activities. This can include advisors, financiers, and potentially insurance companies themselves. We've recently seen lawsuits, for instance, filed against ING, a large European-based bank, for its kind of alleged failure to live up to its climate commitments. Similarly, in the fall, we saw a suit that targeted McKinsey, the consulting company, alongside a number of oil and gas companies for allegedly coordinating a campaign to hide the global warming impacts of fossil fuels. Another category, and a really interesting category of claims for practitioners, are adaptation claims. These are claims that arise from a defendant's alleged failure to plan for or adapt to the physical, societal, or legal impacts of climate change. These claims can be really, really diverse. They range from D&O claims against directors and officers who make corporate investments in activities that might be harmed by the global energy transition, to professional liability or product liability claims against architects, engineers, and manufacturers who fail to consider the physical circumstances of the change in climate. For example, one risk area here could be a manufacturer who ships sensitive electronics across the Pacific Ocean and does not prepare their packaging for the heat extremes that those electronics may face. That's just a tiny example. And because adaptation claims are so nuanced, and because they present some really interesting legal problems for lawyers dealing with insurance claims, I'm going to go into detail about one particular adaptation claim that provides a good example. This one may be familiar to folks. Arkema Inc. is the owner and operator of a chemical facility in Crosby, Texas. In 2016, a report written by Arkema's insurer identified that the Arkema facility was vulnerable to flooding, among other risks, because the flood zones had shifted since the facility was built. Here you can see three different flood maps for Crosby County, Texas, and you can see the little black outline of the facility. So in the 1985 map, it was completely outside of the flood zone. Actually, the one area of flood zone that you can see is in fact a drainage ditch. So there was, aside from that drainage ditch, there was really no flood risk to the property. Similarly in 1996, but subsequently, the next time the flood map was updated, the flood zones had changed. And the facility now largely sat inside of various risks of either the 100-year flood zone or the 500-year flood zone. This was a problem for them because they handle sensitive chemicals. They're subject to regulations about emergency preparedness. And they also, in the real world, they run a risky business that has to kind of take precautions against real world risks. This report was handed to the Arkema. It then sat on a shelf for a number of years. So when Hurricane Harvey approached Texas in August of 2017, Arkema's facility began to prepare for the storm. According to their pre-existing plans, they shut down certain operations, stationed an experienced team on site to ride out the storm. This team included employees who had been at the site for decades and had never ever seen it flood, never seen any flooding issues whatsoever. You can all guess what happened next. When Hurricane Harvey made landfall, the Arkema facility was quickly flooded. This flooding killed power to Arkema's emergency generators and swamped certain refrigerated trailers that were storing volatile organic compounds. This caused an explosion, and the resulting cloud of chemicals drifted out over nearby Highway 50, which was a crucial evacuation route for Houston. 5 police officers who were responding to the scene got caught in the cloud and fell ill. They called for EMTs. As the EMTs responded, they also fell ill as the cloud of chemicals expanded over the county. In total, 21 emergency responders were hospitalized. Highway 90 was shut down, and a significant portion of the surrounding county was evacuated because of the chemical plume. Following the explosion, Arkema and its executives were subject to a series of private lawsuits, regulatory enforcement actions, and actually criminal prosecutions, including one for punching a police officer who was responding to the scene, but maybe unrelated to the emergency preparedness. Now, fast forward to 2024. These legal challenges have been largely resolved, and the majority of associated expenses were paid by Arkema's environmental insurance policies. So that gives a kind of an idea of what these adaptation claims can look like in practice, where the changing physical circumstances change the risk to a real-world activity. And then there's another category of claims that relate to the expanded regulation and expanded regulatory attention in this area that Michelle mentioned. These we broadly call governance and regulatory claims. And these disputes arise from breaches of legal duties that raise issues of law or fact related to the science of climate change. These include greenwashing suits. You might have seen these in the news. These are lawsuits alleging that a company made misstatements or misrepresentations about the environmental impact of its activities. This also includes securities litigation, alleging that a company failed to disclose material climate-related risks to its business. And it includes traditional government enforcement actions related to environmental laws and things like laws regulating emissions. A lot of these laws, interestingly, are not raising novel theories of novel legal theories. Instead, they're coming under tried and true legal frameworks that are generally applicable, like laws against false advertising or securities laws that require companies to identify material risks no matter their source. So these governance and regulatory claims span the gamut from kind of novel environmental claims, claims under new laws, and also claims under really well-established legal frameworks. So with this background, I'm going to pass it over to Susan to talk about the impact of these kinds of claims on insurance policies and how these claims trickle through insurance policies to affect insurers.
Thanks, Martin. Trickle, I like that. Right now it's trickling.
That's optimistic.
Yeah. So in the insurance sector, we tend to really look at risk through the lens of coverage, risk mitigation, and risk management. And, passing climate litigation through that focal point, we can see how the insurance industry may be impacted. The insurance market has already been very meaningfully impacted by physical climate risk, as I'm sure you're aware. First-party coverages, property builders risk, those types of coverages have seen dramatic rise in price, reduction in available coverage, and significant reductions in market capacity, creating significant challenges for insurance brokers. Very familiar with this. The insurance carriers are really working to solve for this through development of new ways to provide protection, but that is still profitable to them. They're not nonprofits, and so they do still have a fiduciary duty. They have obligation to their shareholders. So whatever measures they take, they need to make sure that they're maintaining profitability. Some of the new things that they have come up with include parametrics, which I'm sure you're familiar with, and also blended risk transfer and self-insurance tools. They're trying to be creative. At the same time, they're still trying to, stay above water. Clearly, climate litigation, if it continues to grow at the rate that it has been growing, which I don't think we had that slide in there, but I think over the last 5 years, I think it's tripled in terms of the number of cases globally. And substantial investments have been made in litigation investment, indicating that there is a pretty profound belief that this is going to be a big area for litigation in the future. So if that plays out as we expect it to, the insurance industry faces similar challenges and impacts, this time to third-party or liability elements of coverage. So if we go to the next slide, Martin. On this chart, we've outlined the major lines of liability coverage. So CGL, environmental, D&O, professional liability, products liabilities, workers' compensation, employers' liability, that sort of thing. So these are the major areas of liability coverage. We have then sort of mapped this across the major areas that Martin discussed. Whether a specific policy covers a specific type of claim is obviously always very nuanced. Our favorite caveat in all of our recommendations as brokers is that coverage is determined by the facts and circumstances of each case, and that the terms and conditions of the conditions of the policy under consideration. So, you know, clearly no guarantees here about whether there is coverage or not, but directionally we feel that this is correct in terms of both publicly known claims and where we see the potential for liability to attach on the traditional understanding of a lot of these policies. There's a lot in this chart. In the white paper that we delivered in 2023, there is a really good walkthrough of the details of that. So I would invite you to take a look at that. And then on the next few slides, I've just brought a couple of examples of suits that have been brought against insureds and the policies that were involved for coverage. Hurricane Harvey clearly jump-started our awareness of climate liability. This particular case, unrelated to Arkema, it's a homeowners group that sued the engineering firm that designed the levee that was breached by Hurricane Harvey. The allegations were that the firm didn't consider the impacts of climate change in their design work. So again, failure to adapt. And this resulted in damages to the homeowners. In the case, apparently the founder of the engineering firm stated our 100-year flood standards were not adequate. Okay, well, that helped everybody come to a quick conclusion there, I think. So as I'm sure you're all aware, professional liability policies traditionally respond to an act, error, or omission that results in damages to a third party, and so is triggered by this particular suit. I want to go to the next slide, Martin. Thank you. This lawsuit, and I want to say, not related to the Maui fires. That was just an image that we chose, but this lawsuit was filed in 2020, so long prior to the Maui fires. Some counties in Hawaii sued Aloha Petroleum, alleging that their misleading statements to the public about the impacts of greenhouse gas had resulted in damages. If you look up this particular lawsuit, you can see pictures of, you know, water going over the patios at certain, you know, very fancy spas and retreats. So alleging damages to property value. So Aloha then in turn submitted this claim to their general liability carrier seeking coverage for defense costs and loss. And the carrier denied coverage, and so was in turn sued for bad faith. A couple of interesting points are being considered in this lawsuit. One is under the definition of occurrence, can intentional willful behavior be considered an accident? And another one is, how does the pollution exclusion apply? Or how does the definition of pollution apply? Is a greenhouse gas considered as a traditional pollutant, or is it something different? And this will certainly have meaningful impact in terms of how the commercial general liability policies with pollution exclusions on them apply. Many of them are occurrence-based, and many of them go back for many, many years. So we could be looking at some, you know, significant. I don't want to say that we're watching history repeat itself, but to some degree it may. All right, and then I'm going to turn it over to Michelle to talk about mitigation measures.
Thanks, Susan. So there's a couple of slides which I'm going to talk to here. This first one on policy terms and principles which impact on cover. I think it goes without saying that, Susan's already said, every piece of climate litigation is different, and the type of policy which the subject of the notification will vary considerably. Susan's mentioned some of the different lines, whether it's D&O, general liability, product liability. And once that notification is made, the policy coverage review takes place. It's what I used to do quite a lot of, to determine whether policy will respond, if there's any sublimits in place, any exclusions, and obviously the extent to which policy coverage disputes can then ensue. Now, yes, there are obviously some types of claims where seeking cover can be more difficult than others. But equally, a number of insurers, particularly London market, have come out and said, actually greenwashing claims, unless there's fraud or other criminal behavior that's determined by a final adjudication, those types of claims are precisely what the D&O policies are there to respond to. So, I won't go through all the different areas on the slide, because I think in the time we've got, if I go on to the next slide, what might be more useful is just to provide a bit of insight into my sort of day-to-day at the moment, and actually how insurers and reinsurers are thinking about this in practice, and the risk assessment practices that they have in place, and what insurers are essentially, and reinsurers frankly, are doing as well to get comfortable with the risks they're writing, but more importantly to understand potential exposure under those policies as well. So just to give you some examples, as I referenced earlier, the insurance market needs to be able to withstand multiple catastrophe events in any given year. And one way to stress test the market is by way of what's referred to as realistic disaster scenarios, RDSs, which essentially are stress tests for insurers, but also syndicates at Lloyd's as well. And these RDSs are regularly reviewed to ensure they represent the material catastrophe risks. Now, what we're starting to see now in the insurance market is actually climate litigation RDSs. So I've worked on some RDSs recently where we're looking at greenwashing risk, for example, and that involves looking at the policies which could be exposed to greenwashing risk. We're looking at the changing, and these are global insurers, so they're writing business in a lot of the large markets. So we're looking at what's happening in the US at the moment, the sort of climate and ESG task force, what they're saying about greenwashing. We're looking at real big developments actually in the UK at the moment, a new piece of legislation, similar in Europe, similar in Australia. We're looking at what impacts that will have across different policies. We're providing sort of qualitative overview of that risk, but more importantly for the insurers, I sit with a team of a number of actuaries, so we're combining the law and the actuarial science as well to actually then model what these risks could look like in terms of exposure, which obviously then feeds into insurers responding to these RDSs, ensuring that their capital is of an adequate level. So that's one example. Martin talked about mitigation claims. Obviously, that's a particular risk for fossil fuel companies. And we're seeing claimants, or plaintiffs, I should say, seek compensatory damages for losses which they're alleged to have occurred as a result of defendants' greenhouse gas emissions. And that cover is often sought under general liability policies, which, as Susan said, are occurrence-based in nature. Now, that is essentially a historic liability. Now, for runoff insurers who often purchase discontinued portfolios of insurance risk, if they are an entity, by purchasing that book, they are releasing that insurer of operating capital, essentially, but they're assigning risk, the liability, to the runoff insurer. And those runoff insurers want to carry out an assessment, or want us to carry out on their behalf an assessment of their portfolios to understand what type of exposures could be in there. Now, what we haven't mentioned is the growth and attribution science, which is quite a driver in a lot of this type of litigation. And I'll just very briefly mention one case, which is Luja against RWE, so Germany's largest electricity provider. And it's worth, I won't go into detail now, by all means have a look in your own time, but it's a case which has been running for a number of years. I've been talking about it for at least 7 years now. But Mr. Luja is a Peruvian farmer who, with support of German Watch, which is a similar organization to Client Earth, is suing RWE because his town in Peru is at real risk of flooding due to a glacial lake where the volume has increased significantly in recent years. And he is suing RWE for their contribution, what he is alleging is their contribution to greenhouse gas emissions. So the claim is only valued at $19,000. It's a certain percentage of RWE's global contribution to greenhouse gas emissions. But it's one of these examples of a climate litigation test case. And as you can imagine, it's being watched by a number of entities, because whether you're insurers or a corporate entity, the large greenhouse gas emitting companies, we understand who they are, we know who they are, we know what the risks associated with those companies are. But those types of litigation, like the RWE Luya one, are very important, and as are others, there's others as well, which insurers are watching, because the outcome of those will be influential, shall we say, in what may happen to some of these books, which they might think, oh, we can sell these books off, but actually who's going to buy them if those types of risks are there? So there's a lot of really interesting discussions in the market about those types of losses. And you will have seen the Shell case, the DNO case in the London courts wasn't successful, but again, fossil fuel companies are certainly more under the spotlight than perhaps has ever been the case. But also we're spending quite a lot of time looking at business that's being written now. So we're looking at underwriting frameworks. We're doing quantitative and qualitative risk assessments across specific portfolios, specific lines of business, really to help underwriters understand the changing risk environment and how that impacts on potential exposure. There can be very significant numbers attached to these types of claims. I'm sure you're all very familiar with the PG&E, which was the first climate bankruptcy, which was a real example of actually we shouldn't be looking at climate in physical transition liability risk. We need to understand how the physical impacts of climate, whether that's an increase in wildfire risk, for example, can impact on the litigation cases against directors and officers as well. Martin talked about governance and regulatory claims. The sheer volume of new legislation is such that there's a lot for companies to keep track on. There's a lot for underwriters to understand what the risks are, particularly as there's more corporate reporting requirements. There's something called the Corporate Sustainability Reporting Directive in Europe, which will be impacting companies in the US as well, for example, and obviously greenwashing risk. And what's important for insurers, as Susan said, that they're not charities, but they want to understand the risk. They want to help support their clients. They don't want to walk away from clients, but they need to support them, and they want to support them with their transition. But they also need that education piece as well to understand what they should be doing from a capital perspective, pricing, reserving, what the regulator's asking for them. So there's a lot to consider. It's a really interesting time, not least as a number of insurers themselves are trying to transition to net zero whilst faced with these different litigation risks. So there's a lot going on, but yeah, it's an interesting space to be at the moment.
And I'll just jump in and add, I think a lot of Michelle's comments are focused on how the insurance carriers are responding to these new risks, appropriately so, given who our clients are. My clients tend to be the folks on Main Street. And so we are trying to work with them to develop ways of evaluating the potential for climate litigation, because there are so many cases that are still in the courts and have not come through yet. Because we don't have a lot of decisions yet, it's very difficult to start looking at trending. And even more so, you can imagine then figuring out if and how coverage will apply, because that will come next. So we're in the very early stages of evaluating the process of all of these cases and the outcomes of these cases, and keeping our eye on it so that we can give guidance. There's some, very, things that I think of as directionally correct, but not detailed in any way, shape, or form. But we can do individual tailored reviews with clients about where they may have exposure to these types of claims, and then evaluation of appropriate mitigation measures that they can take, along with confirmation of comprehensive coverage. I think that one is less of a concern right now, because as the cases have not started to attach to coverage yet, carriers have not started to deploy exclusionary language. but we expect that as cases start to impact carrier bottom line, some adjustments in their underwriting appetite will follow. And we'll have to keep a close eye on that so that we make sure that clients have the coverage that they commensurate with their risk.
And so from that, I will move us to our takeaways, which we're tailoring slightly for the legal audience. And first off, the most important thing that we hope you take from this is that while climate litigation is novel, it's a new risk for insurers and for insured companies, it's not random. And as insurance lawyers, ask lawyers who are interested in understanding these kinds of risks, we really have the tools to begin to predict where it will fall, begin to understand what kinds of factors will drive it, and begin to assess whether or not specific policies will cover it. Second, different categories of climate litigation affect different sets of policies and require different responses, both from insurers and from insureds. The risks that a company faces in adapting its product lines to a new environment are completely different than the risks that a regulated entity faces in dealing with new environmental regulation. And those kinds of risks really change the types of litigation that these companies are exposed to. Third, managing this kind of risk requires jurisdiction and sector-specific assessment tools, guidelines, and protocols. This is where we all come in, because as Michelle and Susan both emphasized, the question of whether or not a risk will be covered, the question of whether or not a company faces climate litigation risk is a highly jurisdiction-specific, fact-specific question. So while we can talk about broad dynamics and while we can kind of directionally point in the right way, there is a need for kind of clear-eyed assessment of the risks facing specific activities. And those tools are being developed both by insurance companies, by outside organizations, and by companies themselves. But we can all play a part in that and ensuring that this risk is considered. And fourth, carriers can and are beginning to model and assess climate litigation risks to their portfolios. As Susan just said, right now that is not necessarily changing the language that is going out in policy, is not necessarily changing underwriting appetite, but these decisions are happening, and it's something that insurance companies are very aware of and very conscious of, increasingly conscious of, and something that is right at the top of mind for regulators as well. And finally, number 5, insurance litigation around climate change will be shaped by legal battles around a couple key terms in these policies, including pollution exclusions, definitions of occurrence, and fortuity principles. And so the way that these different battles shape in different jurisdictions will really affect where climate litigation risk falls and whether it's borne by companies, by their insurers, or whether that becomes the subject of decades of litigation. So thank you all. We gave a very brief overview of our work. I direct people both to the white paper that was shared in this, in the kind of recommended reading for this, which summarizes our work on understanding the impact on insurance policies, and also the broader paper that I put out over the summer, which was supported by the WTW, called Modeling Climate Litigation Risk for Reinsurers. That one is 130 pages, I think, so it's not a beach read, but it might be useful to people in dipping in and out to understand the dynamics of this kind of litigation. And finally, we have about 15 minutes for questions. If anybody in the audience has questions about anything, or if everything we've said is so crystal clear, we can all go home early tonight.
Certainly not that. Thank you all very much. So let me start off, and if you have a question, please feel free to either chat it to me or raise your hand, your virtual hand. I was struck by something in the last slide that you showed. You don't have to put it back up again, about jurisdictions, because it seems to me that there's something weird about this, namely that the problem is global. I mean, it's not called global warming for nothing. And so somebody in Peru can sue a company in Germany, or somebody in Australia can sue a company in the US. So it's not just like what jurisdiction, like what's the law in Missouri about this if it happens in Missouri. It's like every jurisdiction everywhere in the world is now in play. How do you think about that? Like what it's like,
you're right.
Yeah, go ahead.
It's challenging because RWE doesn't even operate in Peru. But that's something we're seeing increasingly, not just in climate, but environmental litigation more broadly. There's a lot of focus now on selecting the right forum for that piece of litigation. And what you see in climate litigation, particularly from Climate Earth, German Watch, Environmental Justice Australia, they're a very targeted piece of litigation. And I always used to say this to insurers from the outset. If you or one of your policyholders is on the receiving end of one of those claims, you need to take it seriously. They're not the type of cases which you're used to dealing with, that you'll sit in a mediation at 2 a.m. and you'll kind of negotiate over a settlement. They will have been selected for a very specific reason. Unlike a lot of law firms, the Climate Earth of the World collaborate a lot with other similar organizations around the world. So they will build up a case, they'll learn from their experiences, they'll talk to the experts, they'll decide which there's a lot of cases, funnily enough, are happening in the Dutch courts for a very good reason. Likewise in Australia. In the UK courts, we've had some really big decisions recently about parent company liability. So, actually how do you work with some of the environmental disasters which can happen in South America, in Africa, and actually the parent companies are now being sued in the London courts in respect of those. So it's not just climate, it's a sort of changing nature of litigation more broadly. So that awareness, particularly when we're advising insurers, of actually looking at where the litigation is taking place and the types of policyholders and what the triggers are to that litigation is very important, because that all helps them assess the risk and helps the underwriters assess the risk. And I think it picks up on what Susan was saying, that as an individual corporate level, to do a deep dive into risk is necessary, and you have to do a deep dive and understand the risk measures in that particular company and where their exposures are. And that's, a big exercise in its own right. With insurers, it is possible to do more broad analysis, looking at sectors, looking at jurisdictions, building up the data and assessing those trends, which really helps the system in that regard.
Right, but it seems to me like you have to be tracking every jurisdiction in the world, because if the plaintiffs can bring a suit in Australia or Hawaii or Peru, whichever is the most, they'll choose the jurisdiction that's the most favorable to them, and so that you really have to watch every single development of law everywhere in the world.
Well,
yeah, and I think it's building up a network. It's not as daunting a task as it might seem.
Okay.
I'm going to do two things. First of which is going to pitch the Sabin Center's Climate Litigation Tracker, where for years and years now, we've been tracking every piece of climate litigation in the world. So we have a resource that does that. And it's publicly available, all free. We also, importantly in this context, that's actually why our work doesn't necessarily go into the legal frameworks associated with the claim, but instead tries to group claims according to their kind of real world drivers. So adaptation claims are driven by alleged failures to adapt practices. Governance and regulatory claims are driven by trends in governance and regulation. Because that, I think, is important in getting ahead of this, where as opposed to tracking the laws in every single country in the world, which you can do, understanding the things that, make a claim likely to succeed from a scientific perspective or from a physical perspective, that's an important component of this. And then also, of course, there's the way that the insurance policy language is interpreted in the jurisdictions that under whose law those policies are governed, which is a little bit less, a little bit more predictable.
It's like a materiality reference as well. You have to look at what's material both for the company itself and actually for the insurers who may end up responding to the claims.
Great. So I have Peter Kotchenberger on the queue, and anybody else is welcome to raise their hand. Peter.
Thanks, Peter. This was great. I mean, especially some of the perspectives on international. I did not realize the litigation was going there. My question is, so you mentioned, one of the litigation risks are actions against institutions for not adequately considering climate, whether from government agencies or private parties. What about the opposite? I mean, I think some states have positions where you can't consider. I think Florida is an example, I believe. Maybe South Carolina, but where you cannot consider climate change or or necessarily environmental issues as part of an ES&G issue. Is that, what do you think of the coverage? I don't know if any litigation has been filed. I think it's been threatened. What are the insurance coverage issues there?
I'll take a run at that one real quickly. I like to look at that on a very macro level. If those states are successful in implementing those restrictions, insurance carriers will pull out of those states because property coverage has been underwritten forever on the basis of likelihood of flood. So if increased likelihood of flood is looked at as an ESG consideration or climate, and they're no longer allowed to underwrite on that basis, there's no other way to underwrite property. And so carriers will no longer provide coverage for property in those states. The next thing that happens then is the companies that rely on property coverage to run their businesses and also to comply with contractual requirements, if they can't get property in that state, they'll pull out of that state. So it has been threatened. It hasn't come to fruition yet. And I think it hasn't come to fruition yet because a couple of people have thought through how those dominoes will fall and how that will impact the economies of those states.
Thanks.
That's just my view.
What about companies that specifically insurers that specifically reduce or move away from investments in fossil fuel industries, or any company that gets sued because they're not investing, or they're making environmental decisions instead of financial.
On this, I will plug the work of my colleague Cynthia Hannawalt, who works at the Sabin Center and runs, among other things, our initiative on climate risk and resilience. And she has been publishing a lot in the area of trying to understand kind of anti-ESG litigation and purported antitrust actions against kind of climate organizations and businesses that are trying to adapt to climate change. So she has done a lot of really good work on this, and she would be better positioned than we are to answer this question probably. But yeah, I mean, it's certainly it's certainly a risk that people are talking about. I haven't seen it come to fruition in any litigation personally. I don't know if Susan, Michelle have seen that.
Just jump in and say, I think from an investor perspective, there's an increasing focus on transition plans within corporate transition plans and sort of globally looking at transition plans. And I think and that stems back to investor and stakeholder pressure as well in companies. A lot of high emitting sectors are under a lot of pressure to transition. And that assists not just in terms of reducing their own litigation risk in that regard, it also they are having to sort of, for example, provide their scope 1, 2, 3 emissions in procurement. I'm conscious in the US, California sort of has now got legislation in place in terms of the requirements to disclose this. So I think it's quite hard to ignore some of the global noise that's happening in that space. And I know that there are political ramifications to a lot of these types of discussions. So I'm slightly treading on eggshells. But I think my own personal view is it's as a corporate, even as a high emitter, you'll find very few companies now that don't have some form of transition plan. And if you look at the Shell DNO case, for example, in the London courts said, we're not going to get involved with this. It's not for us to get involved with the management decisions of the company, but Shell equally do have a transition plan in place. So there is, you kind of have to look at it in the round.
Thank you.
Great. So there's a question in the chat from Mark Polly who says, looking ahead, how long do you think it will take before the legal framework and environment catches up with the actual change in climate? That's, of course, a very big question, but anybody want to try that one?
Yeah, I can jump in quickly just to say, in Europe, for example, the European Green Deal, the aims are for Europe to be carbon neutral, net zero by 2050. And there, I can't come close to explain the sheer volume of new legislation that's being drafted at European level that's requiring agreement by all member states to be able to achieve those goals. Now, obviously, that's on one part of the world, essentially. But it is really interesting to see the speed at which, where there is a will, the legislation is enacted. Equally, I think there are other parts of the world where those changes can happen quicker than in Europe because there aren't however many jurisdictions to consider and negotiate with. So I think it's probably not answering your question in terms of time frame, but I would already say there are parts of the world where there is sufficient legislation and frameworks in place, and there is a case now of actually how do you expand that more broadly, taking in the kind of socio and economic needs of the countries, because it's all very well for us in Europe to say, well, look, this is happening here, whereas, you know, in Asia, for example, they're living in a very different reliance still on fossil fuels. So you have to be able to balance the two.
Yeah, I would say I'm first off an optimist about our ability as a society to deal with this, as compared to probably, you know, I don't know, 67. I'm probably in the top quartile of people who are optimistic about this in the field. But the actual dynamic that I think we've seen in some of the more recent litigation is, unfortunately, that the changes in climate have been catching up with our legal frameworks. So we have a lot of laws in place that require, you know, organizations to deal with material risk, and the risks are just getting more material. And so, for instance, every couple of months, I use the Arkema example because I really like the floodplain maps, but every couple of months, the US Chemical Safety Board puts out an accident report where they said, oh, this building fell down because it was built in the 70s, and it now faces hurricane wind speeds that are 100 miles an hour faster than anything that had ever hit there before. So we're, in some ways, and I've also, I can't talk about the details of this, but I've seen lawsuits that are just product liability lawsuits brought by people who were harmed by products that aren't able to deal with kind of unprecedented heat waves. And so unfortunately, our legal frameworks might not have to change that much because some of the risks are becoming more severe.
So that's like my air conditioner couldn't keep my house cool enough when it was 120 degrees or something.
It's more like you sit down in your car and get third-degree burns from your car seat, kind of thing. You put your baby in, and then you come back 10 minutes later, and yeah. But I mean, there's also all of the Michelle raised and Susan raised this in conversations that I'd never thought about. But you know, there's this huge potential liability with products that are shipped across oceans and containers, and the question of whether or not that stuff is adequate to deal with changing physical conditions too.
Great. Go ahead.
I was just going to say, I also just want to make the observation that I love Michelle's optimism, but her framework is Europe and the UK. And so unfortunately, sadly, I think we're a bit slower than Europe and the UK. So I don't know, one day maybe we will get caught up, but I'm less optimistic probably than both Michelle and Martin on this.
There are things, the interesting thing about the European legislation is it is starting to capture companies that are trading in Europe. And that's a big challenge, because you look at the Corporate Sustainability Reporting Directive, you look at the Eco Design Directives, that's products coming into Europe. There is, you know, there is a lot of ways in which the European legislation, like it or not, is sort of impacting any company that has ambitions in the same way that in California, you know, that's impacting corporates operating in selling their products in California. It's an interesting dynamic to watch.
I think the interesting thing is you were saying that Europe is challenging because there's so many different constituents to deal with. We have 50, so that might be part of the problem too.
Travis, did you want to come in, or we're almost at the time? So you have a quick one?
Sure. Well, so we'll see how quick it is. I don't know. Reading this, I mean, my sense is that for folks who are bringing these lawsuits, they're interested in combating climate change generally, and the sort of first best solution to that, I assume, would be proper regulation, you know, like carbon taxes and things like that. And so they'll see private tort claims as sort of like a proxy for regulation, you know, like regulation by civil suit, and then they might see the insurer's response to the threat of that litigation as like a proxy of a proxy, you know, like regulation by 2 degrees out, and there could be a sort of optimistic story to say that 2 degrees of separation will nonetheless be maybe more effective than the proper regulation we can actually get passed, and could combat underlying climate change. But a more cynical story would suggest itself, which would be to say that when you're that many degrees of separation out, what you're more likely to see is sort of tactical changes that will address the threat of litigation and not the underlying problem. So like, insurers changing the policy terms, or seeking tort reform, or lobbying for anti-ESG legislation, or all these other things that will sort of mitigate the insurer's risk of climate liability claims without actually doing anything to prevent climate change. And so, I mean, do you have a view about which of those things, like on that spectrum, how optimistic or pessimistic are you?
I want to hop in on this because lets me rant about adaptation litigation, which I think is so important. Because of course, I mean, you're right. We have that slide talking about how easy these claims are to exclude, how easy these claims are to kind of build insurance policies around. And this is where I think there's a huge kind of virtuous cycle in adaptation litigation, which is alleging that some product is not considering climate change risk and it's harming people as a result of that, or some process. And this is an area where adaptation litigation can be very widespread and also often rarely uses the word climate change. You're saying, I was injured by this product, my house fell down in this storm. It might not necessarily be climate change litigation in the way that would make the news. But it's also a situation where it's very difficult for insurers to kind of exclude the climate portion of adaptation claims, because often you wouldn't find out until way, way, way into the process whether or not it was ordinary negligence or climate-related negligence, or what part of the what role climate change played in some harm that happened in the real world. And it's also something where probably the best way to reduce the risk of that is to kind of have building codes and product codes that consider these changing physical circumstances. So that is an area where I'm quite optimistic that litigation can make a big difference. And it's an area where insurers have the ability to, distinguish between good clients and bad clients, for clients who are, have risk evaluation processes in place versus clients who don't. That's my rant. Sorry, I'll give it back to.
It's a perfect rant, Martin, and I think that's exactly where Michelle and I try to work. We try to work in that intersection of helping helping insurers to understand where their risk lies, and encouraging them to, instead of retreat from the market, determine what good climate risk management looks like and afford coverage to those who are practicing that, and also innovate from a coverage perspective the way they have with the physical risk claims that they've had to deal with.
And it's important to say that all insurers are at very different levels of maturity in this space as well. There are some particularly European insurers who are very much leading the way in this space. They were leaders of the Net Zero Insurance Alliance. They're product innovators, and there are others who are just writing risk as usual. And there's a real difference there. And it'll be interesting to see how that market develops.
Okay, well, that's taken us past 5 o'clock. It's lovely to end on an optimistic note on this topic, because there seems to be a lot of pessimism in the world. But I'm very grateful to all of you for sharing what you've learned about this with us. And the problem's not going away anytime soon, even if you're optimistic. So maybe we can have you back in 5 years and see how things have shaped up. Thank you so much for coming.